John.
Hey, Michael.
Hey, John, how are you?
All right, bud.
Good.
You okay?
Yeah, hanging in there. Brooks, how are you?
Good. How you doing?
Good. All right, so let's get this party started. John, are you going to share anything this evening or?
No slides. I do have the contact information, so if you allow me to share,
Oh, yeah. Okay.
I can put that up.
All right, everyone. Thanks for attending this. Let me do this here. Allow to share. I'll figure that out, John. I don't know how to. Are you sure you don't have the ability to do that?
Let's see.
Oh, here.
Request
Okay.
sent.
Okay, everyone, we're ready. So hey, thanks for you guys for coming to this webinar. I don't know how many people are on here, but there were a lot of people who signed up and registered. Briefly, as you know, Brooks Cutter and John Roussos are members or partners of Cutter Law. They're experienced wildfire attorneys. They've done numerous wildfires, and they'll get into some of that of what we should expect now that we're past the 90-day mark. We've done a couple virtual town halls with them. So we're going to just do a brief presentation, John is, and then it's just free-for-all Q&A. You can put in the questions. A lot of these questions I've seen before on the WhatsApp chats and the neighborhood chats, but just briefly, the questions can be complex. I mean, these guys have been doing this for years now. And the connection here is, so Brooks Cutter is like family to me. His brother, I went to private school back in Washington, D.C., and his brother actually lost his house on Chautauqua during the Palisades fire. So he's got like kind of a vested interest here in terms of family in the community. His son goes to Pepperdine. John is experienced as well, did the Maui fires, the northern fires, and also he lost a family home. So he's been through this process before, especially accounting for personal property and the process of going through that. So thanks for joining us, and let's get started here. So John, if you want to do a little quick presentation where we're at now, we're 90 days after the rebuild. Some people have been paid out, some people haven't been paid out. A lot of people are dealing with issues with the California Fair Plan, with the remediation, as they have smokers or houses that are still standing. And so that becomes the issue is the California Fair Plan are telling some people, hey, we'll just clean it. And other people are like, no, we want it basically stripped, walls open to see what we have under there. So you may want to look at that. And the other thing is the upcoming lawsuits here. The two different types or three different types: class actions, mass tort, and the inverse condemnation. You guys can get in that as well. That's your expertise. And then for everyone, just to start off here before, so from my research, there are a couple. The ATF is still investigating the Palisades fire, and it looks like there's some issues here. We all know that presumably the New Year's Eve fireworks started the January 7th fires, maybe at some point, because the origin is up there by Skull Rock. There's two other issues. There's a lawsuit filed where attorney is claiming, or the survivors are alleging, that there were two fires. There was the initial fire, then another fire started about 12 hours later from down utility lines, wooden poles, and that would lie on DWP. And then there's another, presumably another spot here where for years, DWP have been trying to replace the wooden utility poles up by Skull Rock, and they were stopped due to some destruction of endangered species flora, which is the milk vetch plant, which is supposed to actually help prevent fires. Anyway, some of the metal poles were replaced, some weren't, and so there were wooden poles up there. The lines were energized at certain spots, so that could have caused another fire as well. So there could have been concurrent causes. So take it away, John. I'm going to stop talking now.
Appreciate that introduction, Michael. Yeah, we've to get everybody else up to speed with where we are. We've stayed in touch, Michael, since the last time we did a presentation, as things have kind of developed, and we thought it'd be a good time to get together here again and answer people's questions. First, to do a quick update on where things stand with the litigation, or what we know on the litigation front, and then kind of turn to everybody's questions. So on the litigation front, Michael really summarized it, right? We know that there is the January 7 fire up at Skull Rock, and that looks like it was the kind of the preliminary thought is that that looks like it was ignited by fireworks. That still's under investigation. As it relates to the people that had losses caused by that initial fire, what we're looking at and the way that we're setting things up is to file a lawsuit against LADWP for its handling of the fire suppression, the equipment that they had up there, the fire hydrants, the failure to supply water to those fire hydrants. Now, kind of the legal theory, and Michael, you asked me to get a little bit into the weeds on this. The legal theory there is called inverse condemnation. And what that is people probably heard this before outside of the context of this litigation. But what that is that the government can't take your property, can't damage your property without paying you just or fair compensation for that. Right. And so the idea there is that any damage caused by that January 7 fire, even if it was ignited by fireworks, if the fire caused damage to your home because there wasn't water there to extinguish the fire, well, then there is a valid inverse condemnation claim that can be stated against LADWP. Now, the catch and the problem there is that inverse condemnation only allows you to recover your property damage, right? That doesn't allow you to recover for wage loss if you had a building, a business. It doesn't allow you to recover for your emotional distress for everything that you're going through now post-fire and will be going through as you continue to recover. It also doesn't allow you to recover for, if you're one of the people who had personal injury because the fire burned you, or if you had a close brush with a fire and you were in fear for your life. Inverse condemnation doesn't allow you to recover for those items of losses, those harms that were inflicted on you. So the second part that we're looking at, and Michael, that you alluded to, is the potential that there is a second ignition, a second cause of the fire. This one is, again, an LADWP. There were utility lines up there that initially LADWP was promising everybody were de-energized, had been de-energized for years and years and years. But lo and behold, it looks like now the information that's been confirmed and that is being firmed up is that, as a matter of fact, those utility lines were energized and they had been. And those are a potential second fire ignition source. If that's the case, it's a different legal theory. It's no longer just inverse condemnation. Now it's a whole nother legal theory that allows you to recover everything that has been, every harm and loss that you have sustained, whether it's property damage, business losses, emotional distress. Everything that you're going through and everything that you will go through can be recovered under that second utility related theory of responsibility. Now, I'm sure there's some folks that are saying, well, I'm not sure if I'm the first one or the second one, or maybe it was both of them, both causes that burned my property or caused me harm. If that's the case, then both causes are responsible, and you may be able to recover the full panoply of everything that has, that you've been through and you will be going through. So those are kind of the two kind of big updates. That's where things. That's where the investigation currently is focusing. You asked about class actions, mass actions. These inverse condemnation and utility origin lawsuits, you would be an individual banding together with other people that we represent and filing a lawsuit, but you would be treated as an individual. In a class action.
I can speak to that for a second, John. Because we've done both, right? We've successfully sued State Farm on a class-wide basis for how they've treated people in handling their property depreciation. So we understand that can be an important tool. But in these cases where people's homes have burned down, we always pursue those cases for each person individually. There will be people who will file class actions and try and kind of parasitically glom onto this litigation. But the truth is that everybody should be individually represented, and that's our plan, to individually represent and give everyone individual attention in these cases. In the recent Maui fires, for example, we represented individuals. There was a couple of firms that came in and tried to have people, be part of a class, and virtually everybody came out of that and ended up with individual representation to make sure that they get every penny that they're entitled to. And so I think that's super important, and to emphasize that our firm has the experience, the resources to represent everyone on an individual basis in this case. And to your earlier point, to see what the right fit is for you in terms of a legal theory, whether it's going to end up being DWP or whether we're going to end up, with a utility-based liability, which is going to be better for us, and hopefully both.
And so, John and Brooks, and going that route right there, the question I have for you, because some people want to know. So if you're representing clients and Acme Law Firm is representing clients and Doe's representing clients, how does that come under the same umbrella? Like, for example, Maui had a $4.3 billion settlement, or around a $4 billion settlement that was paid out, or not paid out. It was awarded, right?
And there's a tentative agreement. There's
sorry?
a lot of litigation still happening
Yeah.
between the insurance companies and how big a chunk they're going to get of that.
And so how do the law firms work together? As a team?
So what we do is we collaborate and split up the work of proving liability and taking on the defendants in taking depositions, reviewing documents, collectively pooling our money, which we advance to make the litigation work. And that's something my team has a great experience with. We've been court-appointed leaders in numerous different litigations, either as leader, the sole leads or co-leads, or members of plaintiff executive committee. So we're in a great position to do that.
Okay. And then here's another question here for you guys as we move on to, if everyone wants to start putting questions in the box, you can do that, and we can get to those questions. So the question I have for you is, so it's been going around, and I've heard this too from another attorney, and people are recommending, if you're looking to get involved in a lawsuit to make yourself whole, the best thing to do at this point is not to sell your property. Can you go into that and explain why in terms of a damages perspective?
Go ahead, John.
Sure. So you have the right and the ability to sell your property. It doesn't cut off, as some folks have suggested, it cuts off your ability to recover. But what it really does is it really limits the amount of damages that you can recover. So easiest way to illustrate is by an example. So let's say I've lost my home, I've lost everything in it, and I decide that I'm not going to stick around and wait for the people that burned down the Palisades to figure out how we're going to put it back together. So I sell. I sell my lot because that's what's left, and I'm going to get fair market value for whatever I can get for it right now, which is, you probably have seen from the people that are papering neighborhoods and emailing and offering to buy lots, is not very much. So the recovery for you under that situation where you sell your property is going to be the difference between the fair market value of your home when it was taken from you by the fire and what you sold it for. If you are able to stick it out, which is a better option for you, if you're able to do that and you rebuild your home, then you will get the full cost of rebuilding your home at today's costs. And then you will have a home at today's value that is a brand new home that's rebuilt like your old home was. So that's significantly more than the difference between the fair market value of your old home, what was a 1950s home, whatever it may have been, the difference between the fair market value of that and what you were able to sell the lot for. it's going to be significantly less than what you will be able to get at the end of a lawsuit. Does that make sense, Michael?
Yeah, that's great. And thankfully we have some questions coming in too. But before we start to get these questions, here's another question for you guys as experts. Okay, so we're a family of 5, our house burned down, complete destruction, or we have a smoker, right? But we've been displaced. And I got 3, 4 kids, right? Or 3 kids, okay, family of 5, and my wife, right? Or spouse. What do I do for those kids 10 years down the road when they're still emotionally distressed from what's happened? You know, the loss of the home, displacement. How do you calculate the emotional damages for those kids? And do you have a case example for that?
Yeah, so calculating emotional distress, Michael, that's something that we really rely on people's kind of everyday experience. I mean, this is something that we do day in and day out. The courts across the land do day in and day out. For example, in some of our Northern California cases where we got recoveries from people, you're talking about 6-figure, hundreds of thousands of dollars for what you're going to go through, because it really is no joke. What you're going through is terrible, and our law recognizes that. So there's a full expectation that that under either theory, or rather, if there's a utility cause for the Palisades fire, that your significant emotional distress will receive the due compensation that it's entitled to, and that's very often the 6-figure range.
Right. And so, if it was like regular litigation, it would be, okay, well, did this person go to a psychiatrist? Did they go to a doctor? Do they take Advil? Do they take this medicine? I mean, do you have to document all that? Or, how does that work?
Well, it would be best if you do. The idea is that it's always easier to create contemporaneous information. What you're going through when you're going through it, because one of the survival mechanisms that all humans have is we all forget as we go through. We have to forget the trauma that we go through. Otherwise, it would be hard to go through life. So it's a lot harder after you've gone through it and after you've put that behind you to remember exactly how bad it was. So it's always better if you go to your doctors, you get their help, you have them diagnosed, not only for your case, but also for your health and your well-being, right? Offload some of the stress, find techniques, find help with what you're going through, because it is so real, it is so significant. Also, Michael, I wanted to point out that in the Northern California cases, that was where PG&E was in bankruptcy, and so the recoveries there were limited by the bankruptcy filing.
Mm-hmm.
There was a case in Oregon that was recently that jury came back and hit the utility with $60 million. It was a record-setting jury verdict. The jury wasn't having it. The jury wasn't buying any of the utilities' excuses, and it compensated those people fairly for what they went through. And they went through hell, just like what you're going through right now.
Right. And that's a good thing. Jurisdictional wise, when the lawsuits start to get filed, and we can get into that, some questions about when they're going to be filed, where would this be filed? In Los Angeles, Santa Monica, downtown LA, or where are we looking here?
Yeah, we're looking at LA, downtown LA.
Yeah. Okay. Yeah. And so for something like this, and the jury pool would be favorable to the survivors, I would assume, because it wasn't just the Palisades. You have Altadena, Santa Clarita, and you have other areas as well.
Yeah, obviously what everybody wants is they want a fair jury. They want a fair shot at being treated fairly by the justice system. And your fellow Angelenos have seen what you've been through. A lot of people moved into town, stayed at hotels, apartments, things in town. So that's a group of people that really understand what you're going through.
Right. So audience out there, peeps. So just remember, down the road here, the family members will be taken care of as well, regarding, legal representation, any type of settlement down the road, or jury award. So on that note, I just want to start lobbing these questions out at you from the audience here. so this doesn't become a boring live webinar. Okay, number one from Rebecca. What is the statute of limitations on these two major types of claims, and how long do we have to decide to file a claim?
So the statute of limitations for inverse condemnation is 3 years. Government tort claims, general government tort claims are 6 months. So we are treating this under the shorter statute of limitations because we don't know what the facts will ultimately bear. So it's better to be conservative. It's better to be safe and move sooner rather than later. We still got a little bit of time here. We don't want to move too soon, but at the same time, you want to be within that 6-month period or the 1-year period and get your lawsuit on file. You have 1 year to get your lawsuit on file.
So, and we're looking for it. So basically, on the safe side, we're looking to sign up with the firm, file something by July 6th, right? With that July 6th, July 7th, yeah.
Yeah, so you would be 6 months from the fire.
From January 7th, yeah.
Yeah. And my recommendation is, don't wait until June. Don't wait until July. Talk to lawyers, whether it's folks at my office or other lawyers or, second opinion, whatever it may be. Start talking to lawyers now. Find the right person to represent you. Find the right law firm that you're comfortable with. Because time moves fast and you don't want to be moving right up against the statute of limitations. That's how things get messed up and you lose your rights. So start now. The deadline is for us to get things filed. It's not the deadline for you to start looking at things.
Right. And so on that note, one more thing for the next question here, John, and Brooks, you can help this out, is regarding the actual lawsuits themselves and filing them. Is there, in terms of a second opinion, is there, like in general, from the prior webinars we've had here, in general, most firms are charging a 25% contingency fee. They are not touching the insurance policy. The 25% is coming from where? Just to explain to people.
Well, first, Michael, I'm glad to hear that other law firms are following suit. That's where we are. We're charging 25% of any recovery we make against a third party. And what that means is we don't touch any money you get from your own insurance company unless we have to file a lawsuit against your insurance company. And before that would happen, we would have a conversation and you'd be clear that that's what you want us to do. So the 25% would be from a recovery against DWP or whoever else ultimately ends up being responsible for the fire that destroyed your home.
Right. And in prior webinars, one last thing to touch upon that. Some people I know who have sought legal representation and signed up have also gotten signed up with public adjusters who are taking between 10 to 15%. As I told them, I said that's unnecessary because if you have a firm like Cutter Law, there are others out there that you don't need the public adjuster because you guys are also doing that work as well. Is that correct? Or
yeah, and what we do, Michael, is we have a contractor that we work with who helps. So we'll take a step back. Public adjuster helps you put together an inventory of everything that you had in your home. The idea there is they've got software, they've got lists, they can help you much more quickly put together an inventory of everything without dropping or forgetting or losing things that you had in your home. We have a contractor that we work with who was a public adjuster, who was an adjuster with an insurance company, and he went on his own and he charges a significantly reduced rate for what he does, to the tune of a couple $1,000s versus 10 to 15% of the recovery that you get on your personal property. So, my advice to people is much like yours, Michael, is that you're already short on insurance. You already know that your personal property is going to be significantly more than your coverage for personal property. Don't give away that 10 or 15%, right? There are just too many easy things you can do. The insurance companies are going to look at your home. They're going to look at a partial list that you put together and probably be paying your policy limits to your personal property. then you can work with our contractor and get the full list put together, and get the full valuation through the lawsuit.
Right. Okay, so thank you. And so I'm gonna move on next to Tracy. When do you plan on filing your lawsuits? Kind of go through that by the deadline, which should be around July 7th, 6th. But like most attorneys, you don't want to get caught on a deadline and have some statute limitations issue and some legal malpractice. So I would say way before then.
Yeah, absolutely.
Yeah. What is the minimum, from Roseanne, what is the minimum amount of loss one should have incurred for a lawsuit to make financial sense? For example, condo or town homeowners don't own the land that they live on, and renters usually only have possessions as well.
Yeah, I guess the question is, are you planning on giving a gift to LADWP or whoever else caused the fire, right? Are you planning to let them off for what they've done to you? I don't think so. If it's me, if it's my family, any amount, you don't get to get away with this. You will be held accountable, whether what is uninsured is $5 or 5 million. You need to be held accountable. So I would be a part of the lawsuit myself. And that's what happened with my family. We were part of the lawsuit because you need to be held accountable. This can't keep happening.
Great. Anonymous, does the LADWP decision to leave the reservoir empty for so many months represent a conscious disregard for public safety? If so, how does that impact potential liability in litigation?
So the language conscious disregard of public safety, I suspect that that's language directed to the question of punitive damages. You can't get punitive damages against the government. Does it constitute a reckless disregard of public safety? I think the proof's in the pudding. We all saw what the fire did, and it was, a predictable situation. It was a known situation. So I think that answers itself, but it doesn't increase the pool of damages that you can recover from the government. What it does do is it satisfies the requirement that there was a plan that the government was acting under so that you can recover in inverse condemnation, right? In inverse condemnation, you have to be able to point to a decision that was made by a decision maker, right? Not some lowly guy who dropped a match while he was wearing an LADWP, work shirt. A decision made by a decision maker is a policy matter. Leave this thing empty, leave it empty for 11 months, leave it empty during a fire season, leave it empty during a historical wind event. That's a policy decision. That's why inverse condemnation applies under these facts.
Great. Okay, from Tracy, if you do sue the DWP, how will you deal with statutory immunity?
So two answers to that, and that starts to get out in the weeds a little bit, so I'll try to keep it as unconvoluted as possible. Under an inverse condemnation theory, that's a California constitutional right. There are no immunities that apply to inverse condemnation. If what you were doing was you were suing not under inverse condemnation, but under a government tort theory, and that's where it starts to get a little into the weeds. That's separate statutes. It's the government code, not the Constitution. If you were suing under the government code, then you would have immunities that apply, and you wouldn't be able to pursue your lawsuit at all because of the immunities. In other words, the government writes the law, and the government has given itself a lot of protections, but the Constitution guarantees us government can't take your property without fair compensation.
So then, John, what if, for example, if DWP is the main defendant here, is it basically, are they only going to be liable under an inverse condemnation theory and not, let's say, a tort theory? There's
yet another theory if it's utility caused. That would be strict liability. And that's a whole nother statutory framework there, strict liability for a utility caused fire. And there's not going to be the immunity. They're not going to be able to get away with it. It's strict liability, right? They caused the fire. If it's utility cause, they're responsible for everything. The emotional distress, the income loss, the property damage, everything.
Great. Okay, from Rick. Actually, sorry, anonymous. We are in a condo HOA. We are concerned about our board trying to partition or drag out the process and not rebuild. What is our recourse? It's a good question.
So that would be something where you would want to talk with an attorney who does HOA work to get full appraisal of your rights. And this kind of goes back to the issue of solicitation, and what you see so many attorneys doing, where a lot of attorneys have jumped in. There's a fire, they call themselves fire attorneys without any particular experience. It's important you got somebody representing you who's got experience and knows what they're talking about. HOA work is outside of my expertise, but I know other attorneys that do that. So I can connect you with other attorneys to get the advice that you need to get the answer to that question, while still helping you with your individual loss. And on top of that, once you have a trusted attorney to help you with the HOA stuff, and you have your fire attorney, then you have coordination in your legal representation, and you're going to have the best outcome under the circumstances because you got coordination going on.
Yeah, and for those listening here or watching, you got to be careful out there that what John says, that you actually have an attorney that's going to represent you in that specific field, and they have the experience. So you don't want a DUI attorney filing your claims here. I'm a whistleblower, qui tam attorney, False Claims Act attorney. I'm not touching this litigation. I have no idea. I can help the neighborhood and help everyone in the community to guide you guys to certain attorneys and stuff like that. But you got to have a specialty here. So just be careful with all of the social media ads that you see out there and signing up with attorneys who may not have any experience whatsoever. So the next question is, will your clients have to pay anything ever to you? Will you be charging clients for fees or expenses or expert witnesses? Anonymous.
Yeah, so the way that our law firm works is that we advance all of the costs of your lawsuit. We advance the costs of the experts. We advance the costs of the filing fees, everything that it takes to pursue a lawsuit on your behalf. We advance that. When and if, and it's the and if that's most important, and I think most directly answers your question. When and if there is a recovery against LADWP or anybody else who's responsible for causing your harms and losses, that's when we get reimbursed for the costs that we advanced on your behalf to pursue your lawsuit. That's also when we receive our fee. So if it turns out that all the stuff that right now looks like LADWP, whether in an inverse condemnation or a strict liability context, is responsible for your harms and losses, if all of that turns out to be wrong, and we spent $1 million investigating, we don't present you a bill for your share of $1 million. You get a bill for nothing, not for the time, not for the money that we advanced. That's the way that it works out.
Right, and so that's the contingency in terms of the risk reward there for attorneys. So let me throw this out to you, John. What about if a case settles, you have a client, the case settles for $100, okay? And you get your 25%, client gets 75%. So that $75 the client has, let's say you had $10 in costs for expert witnesses and everything. Does that cost, that $10 come off the $100, or does it coming out of the $75? How does that work?
That comes out of the $100.
Right. So then for Anonymous who answered that question, so then when you're looking at a contingency arrangement, the 75% that you get and the 25% that the attorney gets is going to come off the $90, which is the $10 deducted from the $100. What about attorney's fees? Are there statutory fees where the defendant has to pay those? And how do you handle those?
Yeah, so under an inverse condemnation theory, and to be clear, if it ends up being LADWP, it would be inverse condemnation plus strict products liability, which means you get everything, right? Your emotional distress, your property damage, everything that you've been through, right? If you recover under inverse and a strict products theory, then you can get attorney's fees statutorily paid by LADWP. That is based on your contract with your attorney, and the amount that's paid by LADWP for your attorney's fees is the same as what you pay under your fee agreement with your attorney. So that is something that is there that can also reduce the amount of attorney's fees that you have to pay.
Right. And so for out there, for everyone, Brooks and I both do False Claims Act litigation. We had one case against Medtronic, spinal device company, that settled back in November. And so we had over 10 years of attorney's fees. Under the False Claims Act, under the statute, that had to be paid by Medtronic. So that didn't come out of our client's settlement. So, it's beneficial if there are statutory fees in terms of available, so that doesn't come out of the client's portion.
That's a huge win for the client. Yeah.
Yeah. And also it incentivizes the attorneys as well to know that, hey, they're going to, at the end of the day, they have their own billing, they have their statutory fees, and they have to go to the defendant and say, hey, I have $2 million in attorney's fees. And they battle with the defendant, saying the defendant's like going to say, well, it's duplicative work or this or that. I'm not going to give you that. Let's negotiate or let's mediate. So that's usually how that works. Okay, from Rick, I have a question on insurance coverage. How can a homeowner position to receive the extended cost replacement coverage upfront without being forced to rebuild immediately? Assuming that actual estimated replacement cost is greater than the property cost limit, it would be helpful to get paid up front so the insured has flexibility on when or if to rebuild.
So your insurance policy is going to say that you get paid your extended replacement cost when you do your rebuild. So as you're going into contract, that's when you're going to be able to start accessing that money, right? You break ground, you start getting draws. That's when you access and you get the benefit of your extended replacement cost coverage. No insurance company is going to pay you in advance before you start the rebuild process, your extended replacement cost coverage. And that kind of, Michael, goes back to your initial question at the beginning of our webinar here about selling and leaving, right? Versus staying, rebuilding, tapping that extended replacement cost coverage, so that what you do is you build, an equivalent brand new structure that's going to be worth more than the older structure that you had before the fire, right? And so there is an incentive or a value to you for doing the hard thing, sticking around, putting up with everything you're going to have to put up with, and making sure that LADWP and whoever else caused this fire is held accountable.
Right. From Alicia, how do we join this lawsuit? Where do we sign up? Our home is standing, but we have plenty of damage, and I lost my home business.
Okay, so Michael, I'm going to share my screen here. This is the contact information. You should be able to see the contact information for my law firm. The email is wildfire@cutterlaw.com. You can email there, and I've got staff that is going to be able to quickly get back to you, set up a call with you, get information from you, and then they set up calls and meetings between myself and our clients. Our website's there, cutterlaw.com, and you can also call us at the office, 888-285-3333. Take a screenshot here. I'll put this back up in a at the end of our meeting in case anybody needs it. But the easiest way, wildfirecutterlaw.com. It's the easiest way to reach us, quickest way to reach us.
From Anonymous, if a second fire started 12 hours after the first one, and there is different causes and liability for each, how would anyone know which fire burned their home?
Yeah, and that's part of what the attorneys do in these lawsuits, right? We track the history of the burn pattern when you got burned, right? And kind of in there in your hypothetical, the extinguished fire, then 12 hours later, a second one. Well, if the first fire is out and your home's standing, then you're probably burned out by the second fire. But that's the kind of stuff that we're able to hire experts to get answers to.
And I don't think for the Anonymous there, the one of the problems has been a little bit of the transparency issues. So we don't know yet, kind of like the LA investigation of the fire has been kind of shrouded in mystery. The ATF is going to take its time here, but it's pretty detailed work what they do, as you say, in terms of tracking the burn scar and all the other residue and leftover materials and things like that. So, I mean, they're pretty professional about doing that, but that does take time.
Yeah, and Michael, to kind of build on what you were saying there about the investigation, folks can Google the Lahaina fire investigation, and you can see hour by hour, structure by structure, area by area, the progression of the fire, and you're going to have a pretty good idea of exactly how detailed this work is, and how definitive the information can be. It's really amazing what the professionals in this field can do, how they can reconstruct a fire from the ashes, and from the data that exists. Google the Lahaina fire cause and origin report, and you'll see exactly the kind of report that we're going to get for Palisades.
So, I mean, so for example, John, so for our house, I had no idea about that. So for our house, like down the road, we can find out when our house really started to burn.
Yeah, and Michael, yes, short answer to your question, and then there's also another way, which is, the way that we found out that our house was burned. That was the alarm company. The alarm company had, a smoke detector going off, and then another, and then another, and then nothing,
Right.
silence, right? And so that's the kind of information that's also out there available for that's micro information right there that tells you exactly when your home went down.
Yeah, I think one of the problems, John, a lot of people were wondering is that, like, for our house, I had video cameras, so I could see
Yeah.
the fire engines come and leave. Now I can see later on all the embers going down, but then there was a power outage. And so from that point, no one, I don't think it has any idea. There was another neighbor up the street on Bienvenido who house was standing in the morning, and at noontime it started to burn. I mean, that's just, the next day, that's just, insane.
Yeah.
So, okay, for the next one, Anonymous. Hi, for us in the flat areas that never had a fire come down to our area, which it never has, we were not warned about the water shortage, the firefighter storage, the fire hydrant issues, etc. It seems that they should have said this is not like the fires in the hills that happen almost every year that we can put out. We are all in shock that it used to be the alphabet streets, Gelson's, even Sunset. We had no real warning it would get to us. Thank you. So for the anonymous attendee, I don't know if you're looking at, was there negligence involved, or, what exactly, your question is right there. But John, just to explain, with the way the fire was situated there with the Highlands, it looked like the target was our neighborhood, which is kind of like Marquez and Bienvenida. But the way the winds were, it actually swept down through the alphabet streets really fast. to like the Via de la Paz Bluffs and wiped out that whole area. That is the center of the Palisades, the village and everything. And that's also where Rick Caruso has the village himself. I mean, he, had the money for his own private fire department. But if for the anonymous attendee there, if you want to put the actual question back in there, we can get to that. For the next anonymous attendee, can mobile home residents in the Palisades have damages from the material loss of their leasehold interest? This leasehold interest is the majority of the value lost in the fire.
Short answer, yes. And I've represented lots of people that were in mobile communities in prior fires. So you're not alone. There's lots of people that have been in that same position.
Anonymous, hi, I joined late and wondering if any of these legal theories being discussed regarding tort and inverse condemnation will apply to homes still standing with fire debris damage.
Absolutely. Any kind of property damage is compensable, whether under an inverse condemnation or under a utility cause of the fire, whichever theory ultimately ends up panning out. Any kind of damage is compensable. Any kind of property damage is compensable.
Great. Anonymous, what if the advance of cost exceeds the recovery?
I don't see a universe where that could possibly happen. To be just direct, it's a good question. I'd ask the same question if I were you. And to be direct with you, I don't see a universe where that happens. That hasn't been the case in any of the prior fire cases, and I don't see a way it would be here.
Great. Okay, for Elisa, sorry if this is a silly question, but what if your strategy is not successful and another attorney's group is? How is that handled? Can we switch, or do we have to choose based on strategy now? It's not a silly question, Elisa. That's actually a great question.
Yeah, and it really is. And long story short, we're probably all going to be pursuing the same theories, right? The initial lawsuits were all inverse condemnation, and slowly we're seeing more strict liability lawsuits being filed as the data comes in and firms up the theories. I suspect that we're going to be on both an inverse and a strict liability theory. But that would definitely be something that I'd want to know if I were you, right? I'd want to know before the statute of limitations runs, all right, you've been investigating, what theory are you pursuing? Right? And if it's a law firm that isn't pursuing both theories, give me an explanation of why, so that I, as the consumer, so that I, as the person who was harmed, can make an intelligent and informed decision.
Yeah. And, just as from the attorney's perspective here, and for everyone who's listening, and, if you're a client, clients have a lot of power. So just as you are a patient going to the doctor's office, your client speaking to an attorney, ask what the plan is, what the strategy is. You have a right. I mean, we have ethics to uphold to, just like doctors do. So don't be scared to ask the hard questions.
Absolutely. That right there, Michael, I think is the most important thing when you're a potential client talking to attorneys, is ask those kinds of questions. Right. And if you're not comfortable with the answer to the question, if the attorney can't answer the question in a way that makes sense to you, that's a red flag that tells you that this probably isn't the right guy for you. So yeah, do exactly that.
From Amy, we were sent video of our home burning, and it was my glasses here, and it was a small explosion that clearly shows the distribution power lines were still live at around 4:30 to 5:30 to 5 p.m. I don't know why LADWP didn't shut off the power during the fire, but apparently they didn't. is this negligence worth pursuing in addition to all the other areas discussed?
I'd need more information about what's in that video. I'd definitely be interested in seeing that. I'm not clear from that if we have a distribution line that's dropped and ignites additional fires. If that's the case, then that's a problem for LADWP. But I would definitely be interested in seeing what we're talking about.
And then, John, to follow up on that question, would that be considered kind of like a concurrent cause as well? That maybe there were different spots, some other fire, power lines going down, starting these fires?
Exactly. The idea is that you can have multiple wrong things causing your harm, but so long as a substantial portion of your loss is caused by a utility cause or by the LADWP not having waters in the hydrants, you're entitled to full recovery for your losses from those responsible.
Great. All right. So, anonymous attendee here. For those of us in the flat areas where the fires have never come down before, this is the follow-up question. I think this is the same thing, but there's no question here. Okay, so for that person, there's no question there for us to answer. Anonymous attendee, when might you anticipate or guess how long this lawsuit could go on? 3 years, 5 years? How do you gauge this time? How do you gauge the time this might take? And this is a good question, John, before you started that, because the Maui took about 2 years, right? But that was, you can explain and get into that in terms of the difference of the different timelines. And even the Maui fire, even though there is that, $4 billion, there's still issues with distribution, et cetera, et cetera.
Yeah, so with the Maui fires, and probably the easiest way to answer this question is by analogy to other fires. In the Maui fires, which has been the most recent large catastrophe analogous to Palisades, in 1 year there was a settlement package where the maximum amount of money that could be paid by those responsible for the fire was on the table. After extensive negotiations, it had been established that any more than that, and they were going to go through bankruptcy, slow down the process, delay the day of you getting paid. And then, as folks that were in the North Bay fires know, who went through a PG&E bankruptcy, you're also going to get a significantly reduced amount even after waiting all of that time. So 1 year in Maui, there was maximum amount of money available on the table. For the next year, we have been battling with the insurance companies that have been trying to get themselves reimbursed out of this smaller pot of money that's available for the people who are burned out. So we've been battling with the insurance companies fairly successfully to minimize the amount of money that is going to be reimbursed to them. So now, at the 2-year mark, that the battle with the insurance companies was, is pretty well locked in, and we're probably going to be distributing money. My best guess is by this fall, probably. So, analogizing here to Palisades, I would expect that with the number of good law firms that we're coordinating with, that in a year we're going to have a pretty darn good idea where we stand and what kind of recovery is available. And then can't crystal ball gaze much further out than that, but I wouldn't be surprised if also at the 2-year mark, 2 and change year mark, we start partial distributions of money.
And the DWP also, I believe, is like the largest utility company in the U.S. So I don't know if there would be bankruptcy issues there, but we'll see.
Yeah,
there's always a mismanagement of funds. From Vivian, my house was lost in the January fire. I have California Fair Plan. My mortgage company has also bought a lender purchase hazard insurance for the same property and charged the premium in my account. Now that the CA Fair Plan paid me in full since I was under insurance with low coverage, the lender purchase insurance denied my claim, stating I had insurance when the fire happened. How do I have grounds to ask a second insurance to pay? I don't have enough coverage from the California Fair Plan to rebuild.
I would want to talk to you directly on that one. That one, that's an unusual one. And I'd want to see the timeline, what's in writing, and when they took money from you. I wouldn't be so confident that the lender forced placed policy gets to walk away like that.
Great. So Vivian, John will post his information after this, and you can contact him then.
I'll put it up one more time here while we're on the topic. There you go, Vivian. Wildfire@cutterlaw.com or 888-285-3333. Michael, we got any more questions there?
Yeah, we have some, yeah. And here we go. Ready? Are you fine with time right now, John?
Yeah, I've got another 15-20 minutes.
Okay, so let's try to get through these. Clarifying the mobile home question, does inverse condemnation apply to loss of leasehold value? Is leasehold value included as a property loss under inverse condemnation?
I'm not sure the answer to that question, Michael. I would have to do some research on a straight leasehold interest for a mobile home. My gut reaction from other cases that I've been on is yes, you should have a sufficient property interest, but I'd want to know exactly what attaches to your particular leasehold interest. The duration, the contingencies. I'd really want to take a look at that rather than just give you an off-the-cuff promise that under your circumstances may not actually be right.
Thank you for being honest. Hey, John, look, an honest attorney. Whoa, what's going on here? I'm dogging my own profession here. Okay, from Anonymous. What is Cutter Law's competitive advantage over other fire law firms one could engage?
Yeah, so that's probably your best question to ask every law firm that you're talking to. We're all pursuing the same lawsuit under probably very similar, if not identical, theories. What you're all charging the same amount. So why go with you versus anybody else? And I think probably the most important thing that any one law firm is going to be able to hand you is personalized service while the lawsuit is being pursued. The law firms that are gathering up thousands of clients, they're simply not going to be able to take care of you and provide you the individualized attention that you need, right? Who do you talk to when you call the law firm and you do an intake and you ask for an attorney, right? Are you able to talk to an attorney? Are you able to set up a meeting with an attorney? If the answer to that question is no, then expect that's going to be what happens for the balance of your litigation. If they are easy to work with, they set up appointments easily. They keep the appointments that they set up. The flow of information when you've got a question, are you able to get an answer to your question in a timely manner? That doesn't mean that the law firm should be calling and bothering you, but you should be able to get your questions answered. And so at my firm, we limit the number of people that we represent so that we can provide that individualized level of care to each of our clients.
Great. So how long does it take for these type of cases to be resolved? Anonymous, we discussed that. Maui was 2. John said in about a year, we kind of should know where we're at here in the road ahead. Anonymous attendee, what about those who are left in homes still standing? what would we be looked at, or what would we be looked at differently here? We have a different set of problems, but they are huge. So I think what this person is talking about, if they have a smoker, you know, or soot damage or something, but they hold them standing, well, you know, we kind of talked about this in the beginning, they still have legal rights as well.
Yeah, absolutely. And, and it also depends on, for this particular questioner, what are you dealing with? Are you dealing with an insurance company that won't treat you fairly under your insurance policy? Do you have a smoke damaged home and your insurance company is blowing you off? Are you being treated fairly by your insurance company, and your issue is there's just not enough money there to do all of the smoke remediation that is necessary. Smoke damage is compensable damage under either the inverse condemnation or a strict liability theory. So there is help for you available. It just really depends on what you're dealing with. And that's also part of why individualized care is important, is you need to be, as much as you know what you're going through, you need somebody who's at the law firm to interview you, to get that information, to get a sense for what are the other avenues available to me. The insurance company is telling me, these things. Is that true, right? So I have a number of paralegals that work for me that handle kind of frontline interviews. They get the information to me, so I'm able to look at as many client situations as possible and figure out, okay, we need to do this for this person, that for that person, set up an appointment with with this family, and figure out what the best path forward is. You need somebody to work with you on that stuff.
John, and just to follow up on this question here, I know we're limited for time. What about if someone has, and this might be the anonymous actual question is, what if they have a home that's standing and they had no smoke damage, but their son or daughter can no longer go to Poly High, they had to move to Manhattan Beach, so there is some emotional distress going on. What about those claims are still valid, right? If you're just going off emotional distress?
Yeah, if we're in the universe where we're successful with the strict liability theory, yeah, absolutely. The emotional distress is compensable, and it's going to go, it's going to go a lot deeper, right? You're starting to see it. You're talking about some of those items, and where loss of community really hits home, and that drags on. That has deep, long-lasting impacts.
Great. Okay. Let me scroll down here. What do you think about the following? The Los Angeles Department of Water and Power is dusting off a 114-year-old court ruling to argue that utility can't be sued for not providing enough water to fight the monstrous Pacific Palisades fire because it didn't have a contract to do so.
Yeah, that's going to be under the general tort liability theories. I don't think that under an inverse condemnation theory that's going to fly. You don't have a separate contract with the government when it takes your property from you. It has to pay just compensation, reasonable compensation when it takes your property. I'm not sure that that's ultimately gonna fly.
From Betty, are you considering including the Santa Monica Mountains Conservancy because of the refusal to put in fire roads or do any controlled burns? So what Betty's talking about, will there be other defendants coming down the road here besides LADWP?
There could be, and I'm a little reluctant to get into the details of the of our investigation in an open forum like this. I'm want to make sure that I provide as much general information as I can, but not get into the details of exactly who we're looking at and for what reasons.
Great. Anonymous. Yes, there was negligence. Yes, there was a failure to warn us that this fire was different from the past fires. Yes, there was failure to warn us that the fire was different from the past fires. We had no knowledge of the same thing. Again, oh wait, here, okay. What would the cause of action be? Is there one? So we've gone through that, Anonymous, and the causes of actions. There's two theories, basically, inverse condemnation, and then there's the mass tort, which is a civil theory right here. with strict liability. Is that it, John?
Yeah, you nailed it, Michael.
Yeah, we've gone through that. Can you please walk us through what we can anticipate to experience from end to end once we join the lawsuit through the settlement? That's a good question.
Yeah, so let's start at, you send an email to wildfire@cutterlaw.com. You give us your basic contact information. My paralegal reaches out to you, does books an interview with you, does an interview with you, gets the information to me, and then we start figuring out your individual personal circumstances. What are your harms? Pardon me, what are your losses? What can I do immediately for you? Then as we start moving forward in the litigation process, the lawsuit's initiated. It begins with the filing of a paper called a complaint that tells the other side, hey, you're being sued. Here's what you did wrong, and here's who is suing you. At that point, we then get the power and the ability to issue subpoenas and do other things to get documents, get facts, take depositions. In other words, put people in a witness chair, and they got to answer our questions. And when they lie to us, then we're able to really, put them in their place and hold them to account. That process, typically begins at about 5-6 months into the case, and then it goes on for a rolling basis. At some point, both sides get in front of a judge. They file motions, which is an opportunity for people to get in front of the judge and say, hey, judge, here's what our view on the law is, and here's what their view on the law is. And then the judge, gives a ruling, and that helps advance the lawsuit because, all these BS defenses that we're probably going to see about musty, dusty, no contract cases and things like that, those get disposed of. And that happens in every case, right? We saw in Hawaii, we saw up in the North Bay, in the other fires down here, we saw the utilities and the defendants say, hey, you can't hold us strictly liable. There is no inverse condemnation. You got to have these fights and you got to throw out those stupid defenses. And that takes a little bit of time. And as I said, that starts typically around the 6 months after the lawsuit's been filed. And then after that, it's going to be kind of individualized to this particular fire and what's going on. At what point are they going to decide that are we going to know enough, and are they going to know enough that they can decide that, hey, we better start looking at this seriously, sharpening our pencil and figuring out what money and how much money we're going to put up to compensate folks for what we've done. And hopefully this follows a Maui fire course where, that happens at a year. But, we really don't know. That would be my best estimate, though.
And there's other factors that play too to the audience who answered that, the person, because there's political factors as well as pressure from other, I would say, political agencies, et cetera, et cetera. Just always remember next year is an election year. It's 2026. So that may come into play, but that's my own speculation. That's not legal advice. Okay. What percentage is normally your fees? So you get 25% plus unknown fees amount. So it's 25% contingency for the attorney gets 25%, the client gets 75%. Costs, as we discussed, are taken off the top. So it's $100, $1,000, $20,000 that in the settlements for, let's say, X amount of dollars, it's coming off the top. What about the city of LA not trimming palm trees? Is that negligence? That's from Betty.
Is it, it is, but that's going to fall under a general tort liability theory. And that's when you start running into all those immunities. I think this is probably first of all, LADWP, city of LA we're going back to the same governmental entity behind everything, right? Whether they're negligent for 10 different things or one specific thing, they're already in the case. And failing to trim trees may be part of it. But when you're talking about micro items like that, that's when you start falling into that immunity situation.
Anonymous or Ellie, what percentage is normally your fee? We talked about that. So you get 25% unknown fees amount. So it's 25%. Yes. Anonymous, what is the average in all recent fires of the split of recovery between the insurance companies on the one hand and the victim and their law firms on the other?
There's not going to be an average that we can really throw out there to answer that question. They're all totally different situations. And when you were talking about political pressures, Michael, that's one of the huge things that impacts the insurance recovery. Right, in the North Bay fires, there was a pool of funds that went to the insurance companies, and then there was a pool of funds that went to the fire victims themselves. And the pools themselves were very heavily weighted by Governor Newsom and his involvement in the process. So, with the political pressures and how much they impact outcomes, there's really a good average I can give you that it's like a batting average that you can rely on.
Okay. So we only have a few more questions. I'm going to try to buzz through these so we can get out of here, you guys, because John's been going out for an hour and 15 minutes. Okay, ready? Not sure if this falls under your expertise, but our condo was completely destroyed. We still owe money to the mortgage lender. We received insurance proceeds for the rebuild. For condos, this is for cabinets, countertops, etc. And the HOA pays for the rebuild of the structure. The insurance check was made out to us and the mortgage company. Can we use those funds to buy a new home?
So if I heard Michael, you said that the check was made out to the insured plus the insurance company.
Yeah, and they still owe money to the mortgage lender.
Yeah, that's a situation where typically the way that it works out is that if you are doing a rebuild, that can be applied towards the rebuild. Call your mortgage lender. Say, hey, this is what I'm doing. I'm rebuilding. What do we have to do to get this money applied towards the rebuild? And they should be able to walk you through that. And if not, then you've got the wildfire@cutterlaw.com email address. Reach out to me.
All right, just a few more here, John, and I'm going to combine these two right here. Are you planning on limiting the amount of clients, this is from Tracy, that you take for the Palisades fire? If so, what is the limit? And the follow-up for Anonymous is, if Cutter Law limits the number of clients they represent, how do you decide who to represent?
Yeah, it largely is largely a first come, first serve situation, Michael. When we get to the place where I don't think my staff is working efficiently, I don't think that we're able to take on any more work, that's when we're going to pull the plug. That's what we've done in the past fires, and that's kind of my plan in this fire as well. It's a matter of efficiency, and yeah, you take on additional staff and you take on additional folks to help, so that you can maximize the number of people you help. But there's a learning
Please close the
curve,
door.
and I don't necessarily want to have folks training on your case.
Right. Okay. If I already signed with an attorney for bad insurance, for insurance bad faith against the California Fair Plan, am I precluded from signing with you?
No, you are not. And the way that it should work is your retainer agreement should say right out front, this is what I do as an attorney. I'm your insurance bad faith attorney. I'm suing California Fair Plan. That's what I'm doing. And so that right there, you see it in black and white, is what tells you can go anywhere you want for any other work. And it's also a heads up that, hey, I'm not handling your fire, So don't count on me to do your, get your fire lawsuit taken against LADWP filed before the statute of limitations. And you can always just reach out to them and let them know, hey, I just want to make sure that you are not handling my Palisades fire case, just my bad faith case. And the attorney should answer yes. There shouldn't be any problem with that.
Okay, great. I am in a condo HOA. Can I sign up with you for fire damage litigation despite our HOA owning the exterior of the buildings?
Yes, I'm assuming that you have damage to the interior. So yeah, that sounds like something we'd be able to help you with.
And I think that's about it. Is there a way to watch a recording of the meeting? Yes, there is. This will be posted on their website at Cutter Law. And so the last question here is we already covered. Perhaps you've already covered this, but just to understand this, would be a mass tort? Would there be a mass tort case against LADWP?
Yes.
We've discussed that already. There's two avenues, which is the inverse condemnation theory and then the strict liability theory. We will post this webinar because we discussed it in the beginning of this webinar. And then you guys have any follow-up questions? John, you've done a great job. Thank you so much for our community and helping us out. And if you want to post your information again, if you guys have any follow-up questions, contact John, his law firm, Cutter Law, and move forward from there.
Michael, thank you again for bringing us all together to share this information.
Yeah, thank you again. Thank you for your expertise and your time for helping us out. I know Brooks had to jump off, but again, wildfire@cutterlaw.com. The website's cutterlaw.com, and the phone number is 888-285-3333. For those of you out there looking to sign up with various firms, remember we discussed upcoming potential statute of limitations deadline of early July. Do your due diligence and look at other firms, and try to get representation to make yourself whole.
Absolutely. Thanks again, Michael.
Thank you. Have a good evening, everyone.
Stay in touch.
Thank you.